All right, looks like we have a critical mass, so we can get started. Good morning, everyone, and thank you for joining us for today. We're having a critical discussion on the overturning of Chevron deference and its potential impacts on environmental health decision making. My name is Abina Bakenra. I'm a science associate with UCSF's Program on Reproductive Health and the Environment, or PRE, where I run the Science Action Network. I'm delighted to welcome you to today's webinar, which is the first webinar in our two-part webinar series titled The Future of EPA Decision-Making, Navigating Legal and Scientific Challenges. This is brought in collaboration with UCSF's Environmental Research and Translation for Health Center, or the EARTH Center, Earth Justice, the Collaborative for Health and Environment, or CHE, and the Science Action Network at PRE. The decision we'll be discussing today, the Loper Bright Enterprises versus Raimondo case, marks a pivotal moment in U.S. law and policy with far-reaching consequences for environmental regulation, public health protections, and the role of science in policymaking. Before we dive into today's discussion, I'd like to share a few housekeeping notes. As a reminder, the second webinar in this series will take place on December 9th from 10 a.m. to 11:30 a.m. Pacific Time. Part 2, What's Gone Wrong at EPA and What Does It Mean for Our Work Ahead, will feature a series of lightning presentations by public health experts, highlighting key examples of EPA's scientific shortcomings and their implications on public health. Lightning talks will feature topics such as pesticides, new approach methodologies or NAMs, environmental justice, and more. If you're interested in joining this webinar, please use the link in the chat or register via the QR code on this slide. Additionally, we also encourage you to join UCSF PRE's Science Action Network using the QR code on this slide or the link in the chat. The Science Action Network is an interdisciplinary group of over 200 scientific experts, public health advocates, and healthcare professionals who use their collective expertise to engage in policy that advances public and environmental health through public commenting, publications, and more. Throughout today's webinar, we encourage you to engage with us. You can submit your questions at any time using the Q&A feature. At the end of the panel discussion, our Q&A moderator, Dr. Tracy Woodruff, will guide us through your questions. We're privileged to have with us today a group of experts who will help us understand the legal, scientific, and public health implications of the Loper decision. Our moderator for today's discussion is Bob Sussman. Bob is an experienced lifetime environmental lawyer and has argued major cases in federal courts, raising issues about the interpretation of environmental and health protection laws. Bob was the EPA Deputy Administrator in the Clinton administration and a senior policy advisor to the EPA Administrator under President Obama. He has taught courses on environmental law at Yale Law School and the Georgetown Law Center. His current practice is representing NGO groups in court cases and administrative proceedings under the Toxic Substances Control Act and other laws. Bob is a graduate of Yale Law and Yale College. Joining Bob today are two legal and policy experts who will offer their perspectives. Lisa Heinzerling is a professor of law at the Georgetown University Law Center, specializing in environmental and administrative law. She has published several books, including a critique of the use of cost-benefit analysis in environmental policy. She has received numerous awards related to her scholarship and advocacy in environmental law. Lisa is a former public member of the Administrative Conference of the United States and a former chair of the board of the Center for Science in the Public Interest. After finishing law school, Professor Heinzerling clerked for Judge Posner of the U.S. Court of Appeals of the Seventh Circuit and for Justice Brennan Jr. of the U.S. Supreme Court. Eric Olson is a senior strategist and advocate for the National Resources Defense Council initiatives on health, including campaigns on drinking water protection and toxics and products in the environment. For 15 years, he worked as a senior attorney at NRDC before leaving to serve as general counsel and deputy staff for the U.S. Senate Committee on Environment and Public Works. Later, he oversaw food safety and other food-related works at the Pew Charitable Trusts. He joined NRDC in 2013. He rejoined. Olson's work has led to the first major overhaul of the U.S. Food, Drug, and Administration's food safety law in more than 70 years. He holds degrees from Columbia University and the University of Virginia Law School. Finally, our Q&A moderator today is Dr. Tracy Woodruff, the director of UCSF's PRE and the UCSF Earth Center. Dr. Woodruff is a renowned scientist, public health expert, and researcher. She's produced seminal research on how harmful chemicals and environmental pollutants affect susceptible populations, with a particular emphasis on maternal and child health. A national expert in chemical policy, her work also aims to inform and strengthen public health policies and interventions to protect communities from harmful environmental exposures. Prior to joining UCSF, Dr. Woodruff was a senior scientist and a policy advisor for the US EPA Office of Policy. She will guide us through the Q&A portion of this session. With that, I'll turn it over to Bob Sussman, who will lead our panel discussion. Bob, we're eager to hear your insights and those of our panel experts.
Yeah, thanks, Sabina. It's great to be here today to talk about an important and very time-like topic, and it's also great to be on this panel with two old friends and distinguished colleagues, Lisa Heinzerling and Eric Olson. I can't think of two better people to share their insights on this court decision and what it means for environmental health protection. We're going to start off with Lisa, and then we're going to go to Eric, and then we're going to go to B, and then we are going to have a Q&A discussion among the three of us. So without further ado, Lisa, the mic is yours.
Thanks, Bob. Glad to be here. So some of you may remember when the first Trump administration was beginning some years ago, that Steve Bannon, an advisor to President Trump, claimed that the goal of the administration would be the deconstruction of the administrative state. And a lot of people didn't know what that meant. They didn't even know what the administrative state meant. And the administrative state, of course, really consists of the agencies like the Environmental Protection Agency that do the basic daily work of government. And the thing is, this deconstruction is not so much coming through the political branches, although we've seen attempts to do that, but through the courts. And so what I'm going to do first is just set the context for the Loper-Bright decision overruling Chevron. That is sort of centerpiece of today's webinar, but set the context and explain about recent cases that I think you have to understand as part of the story of the Loper-Bright decision. So the Supreme Court is changing long-standing understandings of the constitutional separation of powers, which is really the set of principles that determine the division of powers among Congress, the president, and the courts. And this development has serious implications for the administration of regulatory programs that protect public health. So there have been changes to the law in three basic areas: agency personnel and structure, the power of Congress and the executive to take on important problems, and the interpretive power of federal agencies. And so I'm going to talk about the recent cases and then tell you how I think they're related. So before last July, the Supreme Court had already done the following. It had limited Congress's power to protect agency officials from firing by the president. It had required more agency officials to be appointed through the political process, thus in both cases moving the apparatus of the agencies closer to the president and away from independence. The court had held that Congress may not authorize an agency to address a question of great economic and political significance without speaking super clearly. And the court had held that Congress may not allow an agency to significantly alter the federal-state balance or the power of the federal government over private property without speaking super clearly. So limited agency independence, limited agency's interpretive power. Then last term, the court held unconstitutional the Security and Exchange Commission's enforcement structure in cases of securities fraud, and basically held that a jury in a federal court had to be the one to decide whether fraud had occurred and to impose any penalties. That moves power away from the Securities and Exchange Commission as set up by Congress and toward the courts. There's a similar enforcement scheme that relies on in-house agency judges rather than the judges in the federal courts in 24 agencies. And it's provided for by about 200 statutes. EPA conducts a lot of its enforcement work through its in-house adjudicators. So seemingly separate kind of issue, but very relevant to the work of the Environmental Protection Agency. Of course, last term, the court also overruled Chevron, and Eric will be talking in more detail about the Loper-Bright decision doing that. The court also decided an important case on the statute of limitations for challenges to agency action in many instances, and effectively, I don't have to get into the details, but effectively made possible challenges to long-standing and long-settled agency policy approaches and agency rules. The court also decided that the Environmental Protection Agency had not explained itself well enough in justifying a rule on interstate ozone pollution, and had held in administrative law terms that the agency had acted arbitrarily and capriciously. Very, very tough scrutiny in that case of the agency's explanations for its actions, and also notably, it took place on the court's emergency docket. You may know it popularly as the shadow docket. So all those things last term. This term, the court has in front of it a bunch of cases that have to do with the interpretation of statutes, and again, gives the court a further opportunity to figure out what it means when it talks about how to interpret statutes. These cases involve the Clean Water Act, the National Environmental Policy Act, and gun control at the very least. So what I'm going to say next is I think these developments are all related, and we should consider them in context. There is what I consider to be a perfect storm of circumstances that's facilitating the Supreme Court's assault on the administrative state. One, Supreme Court appointments. 2 of the justices, at least, were picked precisely for the purpose of taking on the administrative state. If you're wondering, it's Neil Gorsuch and Brett Kavanaugh. 2, the Supreme Court has been using its so-called shadow docket or emergency docket, the docket that allows it to decide very quickly whether to stop some action, either from the lower courts or from or stop a decision either from the lower courts or even now, as the court understands its power, to stop an agency regulation from going into implementation. That shadow docket has become, I think, a regular channel for the court's review of agency action, which means the court doesn't have to explain itself. Many times they don't issue an opinion. They don't have ordinary briefing, substantial briefing, and they don't have oral argument. And then at the end of the day, they say yes or no. The rule stays in place or not. While the judicial review is pending, which can take years. So that's one of the factors that I think is highly relevant. The emergency docket also prizes very quick determinations of whether an agency action is valid, which for complicated reasons, I think really works with the court's new clear statement principles for statutory interpretation. The lower courts just look quickly at a rule and they say, oh, we think this is big and important. We'll stay it because we're supposed to look for super clear language and we don't see it. Another thing that has happened is that the Supreme Court litigants that challenge agency action are now often nominal plaintiffs that are backed by billionaire funders. And this itself, I think, is not a great development, but it also has sort of deranged some of the court's processes. And I'll just take a couple of examples. The Supreme Court often doesn't take the narrowest path to decision, but the broadest path. That happened in Loper Bright and in other recent cases. It doesn't answer the question actually presented sometimes. That happened in Loper Bright. That happened in the case I mentioned about property and federalism. The Supreme Court in the emergency docket actually writes the question presented for the parties, meaning it says, I'd like you to talk about this issue rather than having the litigants do that. That's what happened in the interstate air pollution case I mentioned. Another piece of this, I think, and they seem unrelated, but I really think they're not, is that flagrant judge shopping is now perfectly permissible in Louisiana and Texas. There are districts there, federal district courts, that have only one judge. And so if you are industry challenging a rule, you can know who your judge will be if you file in a certain place, and you will know what their attitude towards regulation is. So last, I just want to say that I think there's a curious sort of interaction among some of these cases, and particularly between the cases on statutory interpretation and the cases on agency personnel. So the limits on agencies' interpretive power shrink the power of agencies, right? And therefore of the president, since the president does so much of his work through the agencies. The cases on personnel I talked about enlarged the power of the president. And so what kind of power is the president left with? Well, I think it's destructive power, not creative power. It's the power to fire people, but not to make them do anything important. It's the power to have them sort of, the president break things, but not fix them. It's unfortunately, and please don't blame me for this particular message, this perfectly suits a president who doesn't want to regulate and who is pleased with the Supreme Court's weakening of the administrative state. So this is all not normal business in the courts. These are not neutral principles. This is not, I think, the ordinary way of, or the ordinary method of operation in the Supreme Court. And I just want to say that at the end, just because there are a lot of aggressive opinions coming out, a lot of aggressive approaches to the separation of powers. And it's just not the typical, more orderly way of deciding these questions. Thanks.
Yeah, thanks, Lisa. That was a great beginning and an excellent. Excuse me. I was saying that I thought Lisa's presentation was excellent and really framed the challenge that we're facing, not just with this court decision, but with a host of Supreme Court decisions, which in totality do reflect a judicial war against the administrative state. So now we're going to home in on the Loper Bright decision itself, and Eric Olson is going to walk us through that. Eric?
Yeah, thank you very much. And I'm going to be fairly brief because I think this all fits into what Lisa was talking about. The Loper Bright decision, I'm not going to go into the details of exactly what statutory construction they were considering and those issues. But what's important to realize is that under 40 years of administrative law, there was a court decision known as Chevron versus NRDC. Our organization was on the losing end of that original decision. And basically what the court ruled in that case was that if a statute, if a law is not clear about exactly what an agency is supposed to do, or not clear in its statement of principles, the agency is supposed to get deference to its interpretation. The expert agency is supposed to get deference to its interpretation. basically under Chevron, there were two steps. If the law was clear, then that was the end of the matter, according to the court. And that basically was the way that the court would go. But if under step two, there was any lack of clarity, if there was an apparent ambiguity or silence by the statute, then the court would generally defer to any permissible, in its words, permissible interpretation of the statute by the agency. So for EPA, this meant basically that the agency would be able to interpret the statutes that it had been working with in many cases for decades and was very expert on how to implement it and how to interpret it and what the history of it was. The agency would get deference in its interpretation of statutes. And this was true not only under obviously EPA laws, but also, as Lisa talked about, under numerous other agency laws. So for 40 years, that somewhat was chipped away in a few cases, but generally it was a fundamental principle of administrative law that an expert agency got deference if there was silence in the statute or ambiguity in the statute, which, as we all know, and as I know from my work on Capitol Hill, very often there is ambiguity in laws, and sometimes that's intentional and sometimes it's unintentional, but so many statutes include these ambiguities. So what Justice Gorsuch, who is actually the son of the former EPA administrator, had long argued for overturning Chevron. I think, as Lisa said, there are a couple of justices that this was in their sights for a long time, well before they were appointed to the Supreme Court. The handwriting was on the wall for some that this decision was potentially coming, that Chevron would be overturned. So what the Loper decision basically decided was, interestingly, they said there was, quote, a bare quorum of 6 justices that ruled in Chevron that there should be this deference, and now they ironically don't admit that there was a bare quorum of 6 justices overruling Chevron. But anyway, I'm going to leave that. Fundamentally, what the Loper decision decided was that rather than respecting the expert agency's knowledge of the statute and knowledge of the subject matter, the courts would make their own decisions as to how to interpret any statute. And at this point, no longer would an expert agency get due deference to its interpretation of the statute under the new Loper decision and another decision that was issued at the same time. Basically, the courts are no longer going to be deferring to the federal agencies. There are a couple of potential exceptions. The court did not overrule a case called Skidmore. So if you can make the case that there was a valid, generally contemporaneous interpretation of the statute by the agency, and if that interpretation was consistent over a long period of time and persuasive, then the court might defer to them. But that leaves a lot of mush room. And I think the court, our concern obviously is that along the lines of what Lisa was talking about, consistent with a long history of some of these justices trying to minimize the power of federal agencies, that we could see the courts taking this Loper decision and overturning a lot of agency decisions. Now, one thing I think is worth just contemplating is, what does this mean? And I think we'll talk about this in our conversation afterwards, but what does this mean for a Trump administration? If the Trump administration is interpreting a statute in a way that is what we think is contrary to the statute or not appropriate under the law, does the overturning of Chevron mean that the Trump administration would not, or some other hostile to EPA statutes administration, would they no longer get deference? Could that work in the favor of public health and environmental groups that would challenge an act by a hostile EPA? So that is to be determined. I think obviously, there's so much mush room in this, and a lot of opportunity for courts that are hostile to the administrative state, as they call it, or hostile to, frankly, any public health or environmental actions that industry might not like. We'll just have to see how that would play out in the future. I do want to just mention, Lisa did mention this, but one of the things, there's this a series of additional new doctrines the Supreme Court has sort of created or amplified. One of them is this non-delegation doctrine. I think we may talk about that a little bit later. But there were other potential decisions coming that might also undermine EPA's and other agencies' ability to move forward with public health and environmental protections. And I think the overall direction, as Lisa summarized, of the Supreme Court and this majority was discussed at some length by Justice Kagan's dissent in the Roper case. But I think the concern that we have and many others have is that there is a pretty clear intention for no longer the expert agencies and folks that are elected representatives, folks that work in the executive branch working for an elected official making these decisions, but rather judges that frankly often have their own political agenda and are not elected and have lifetime appointments, which is definitely a concern. So I'm sure we'll talk more about those implications, but I'll leave it there. I think the decision was pretty clear as to where the court is headed, and we'll see how these additional cases that Lisa mentioned that are pending before the court now are going to continue to erode EPA's and other administrative agencies' power. I'll turn it back to you, Bob.
Turn on your mic, Bob.
Bob, you're muted. So now we don't know all the brilliant things you said. You're still muted. I think, Avina, can you unmute him? Is that like possible?
Hey.
There you go.
I am unmuted and apologize for the delay. I wanted to shift the focus to regulatory science and the role that regulatory science plays in judicial decisions that review agency regulations to protect public health and the environment. Chevron is, or rather Loper is not a case that directly addresses the scientific and technical judgments that agencies make. It's a case that ostensibly is about the role of agency in interpreting the words in the statute. But as Lisa mentioned, Loper is one example of a growing and now very troubling hostility to the administrative state by the conservative wing of the Supreme Court and its allies in Congress, now its allies in the executive branch, and its allies in the conservative legal scholarship community. And as such, Loper is part of the trend Lisa described of arming courts with new tools to rein in what some would say are power grabs by agencies. So how does this relate to the science on which agencies base their public health decisions? There are two connections that I'd like to highlight. First, our environmental laws often use scientific terms and concepts to describe how agencies should go about determining whether a polluting activity or a chemical is a threat to public health and must be restricted. However, these terms tend to be either poorly defined or in many cases not defined at all in the statute. For example, one of my, I won't say favorite laws, but probably the one that I deal with the most, the Toxic Substances uh, Control Act and also the Clean Air Act, require EPA to determine whether a particular risk is, quote, unreasonable or significant. In the case of the Clean Air Act, they direct EPA to apply an ample margin of safety. Coming back to TSCA, the law directs the agency to rely on, quote, the best available science and base decisions on, quote, the weight of the scientific evidence. But in all of these examples, the laws themselves provide little or no guidance on what these concepts mean. In other words, what the legal benchmarks are for determining the level of scientific evidence required to justify a decision to regulate, and what scientific evidence is considered probative, and what scientific evidence is entitled uh, to less weight. Um, so does Loper now give the courts the last word on how agency scientists should determine if a risk is unreasonable, or what the best available science for that decision entails? And if so, I think here's the big question. How can a court with no training in toxicology, biology, or risk assessment possibly identify the tools of analysis and modeling which represent the best thinking of experts in the field? How can a court possibly get its arms around that, particularly if it is not going to defer and attach a lot of weight to the scientific tools that the agency has employed? Unfortunately, these are not theoretical issues. They relate to a number of cases that are pending in the courts right now, where industry is attacking Biden administration environmental rules because EPA allegedly misinterpreted or failed to apply scientific directives in the applicable law. And these are significant cases that involve well-known high concern chemicals, PFAS, asbestos, methylene chloride, and probably others as the Biden administration rushes to get out rules before Donald Trump takes office. Now, I want to move to the second issue, which is reviewing is the role of the courts in reviewing how the agency has applied the statutory terms to the specific data at hand. And if you read the briefs in some of these current cases, you'll find very sharp debates over how the agency is interpreting the findings of particular studies, which studies it has chosen to emphasize, and which studies it has chosen to reject, whether the data demonstrate serious health risks or risks which, as the industry advocates claims, are essentially trivial and non-adverse and not worth worrying about. And then how evidence of toxicity at high doses should be extrapolated to variations in exposure and susceptibility in the human population. Traditionally, in the normal world that Lisa described, which seems to be disappearing by the day, the courts tried to steer clear of these debates and defer to agency scientific expertise. And Loper doesn't really say that deference to the agency's scientific expertise uh, is is impermissible. And so, at least in the abstract, uh, agencies continue to ask for deference for their scientific judgments. However, because of the trend that Lisa described, I'm not sure how long that is going to last and whether the traditional willingness of courts to defer to agency scientific expertise is going to erode in light of the polarization that we see in the judiciary and the animosity of many judges to the administrative state. I would also point out that the pandemic marked a low point in public confidence in official science, at least until Robert Kennedy arrived on the scene. And skepticism of government scientific pronouncements, I think, is more widespread in our society generally. And although I have no evidence, is probably more widespread among judges than we might prefer. Um, so I think a big issue moving forward from Loper will be uh, judicial review of both the scientific terms in laws and the application of the specific science at hand uh, based on those definitions and concepts. And I would say that if uh, Kamala Harris were elected and we had an EPA which, for all of its flaws, uh, was adhering to the agency's traditional role, our issue would be whether good science would be swept aside by judges who refuse to give any deference to the science that agencies have used. But in fact, we have a different challenge with the Trump administration, and that challenge is that agency science is likely to become overtly politicized and establish frameworks for addressing the health risks of pollution or unsafe products may unfortunately be replaced by rogue science. And so I think for the advocacy community and for the scientific community, that raises very different issues than we have had in the Biden administration. And we can we can talk about what we want good judges to do going forward. But I think one thing is clear, and I'll stop with this. whether you're defending or attacking science-based decisions of agencies, you can't assume that courts will accept the science on faith. And so you have to be prepared to explain the science, to explain why it's persuasive, to explain why it's backed by uh, uh, peer-reviewed methods, established methods of risk assessment and analysis, and why it's science that should be accepted by the court. Because I think if you can't do that, courts are going to strike down science-based decisions.